I have the pleasure today of introducing Allison Mano. She's Executive Vice President with Health EFX. Also, I have Susan Nash. Say hello. And she is a capital partner with Winston & Strawn. And Brian Brown, attorney for employee benefits and legal counsel for United Parcel Service, UPS. So very glad to have you all on the line. We do have an exciting set of slides to cover. People are really looking forward to these slides. I've had a lot of people email and say thank you for doing this. It's a time that is right, and so we're really going to dive right into the presentation. For you guys to have access to your slides, you simply have to click on the slide itself, and the forward/backward keys will be able to assist. And I'm going to hand it over to Allison and allow you to get started. And then when it's time for Q&A, I will ask the experts from the audience, and we'll go straight into the Ask the Experts. And appreciate it.
Excellent.
I'm gonna go ahead and mute myself.
Great, thank you, Jenny, and good afternoon, everyone. As Jenny said, it is extremely timely. We are right in the middle of we'll call it 2019 reporting for tax year 2018. And with the recent election that happened, we just wanted to make sure that we brought everyone up to speed as best as we can in everything that we know. So we're going to take a quick walk through the history of the ACA and the current landscape. We'll talk about those litigation challenges, that one that everybody is talking about in the Texas court case, what's happening at the states, because we know that the states have the ability to play in this landscape and game we call the ACA. We'll talk a bit about the reporting season that we are now, and especially how and if this shutdown that we are going through right now will have any impact on our reporting season, with the IRS being part of that. I want to cover what's happening with the 116th Congress, and of course we're starting to get those people stepping up and letting us know that they are running for the presidential seat in 2020, and talk about what our crystal ball is telling us about the future. And then you have us to ask all of your great ACA-based questions. So, as we go through, thanks to the incredible creativity of Brian at UPS, we thought we would take you through a walk, as we are from the ACA today, in something that everyone is really aware of, and that's a medical visit. Let's go visit your physician. And the first thing that we do is we go through that history. And if everyone can think all the way back, it has almost been a decade, but before the Affordable Care Act, we had we walked through the history and we had our diagnoses, how and where this came about, how cost, coverage, and care impacted all of the citizens in the United States. From a cost perspective, we were facing high medical inflation. There was an enormous taxpayer burden. In 2013, we have uncompensated care for uninsured individuals cost the taxpayers about $85 billion. There was some cost shifting happening to patients and employers. So in 2005, 4% of employers offered what we term the high deductible health plan, or the HDHP. And by 2011, right as ACA was kicking off and getting started, nearly a third of employers had offered such plans. From a coverage perspective, with that opportunity and it being private-based, there were millions of uninsured and underinsured Americans due to the cost of those premiums and the ability for people to be denied coverage due to pre-existing conditions and some limits that were out there, as well as care. We started to see poor outcomes, preventable diseases becoming more prevalent, and this seemed to be the underpinning of why this became the main focus under the Obama administration. So after that history, every good physician puts us on a treatment plan if we need one. And we always referred to the ACA as the three-legged stool. What is holding up that law that's going to bring us into coverage for all of the citizens of the United States? And part of that three-legged stool were the mandates, and we had the individual mandate and the employer mandate that required everyone to have coverage either through the employer-based system or through an individual coverage level. We had market reforms. Our plans had to offer what we term adequate or qualified coverage, and then a new based marketplace where subsidies could be offered to buy that individual coverage based on income and at the household level. From an individual coverage mandate, this was a tax for not having what was termed minimum essential coverage. As of 2018, that tax penalty was 2.5% of household income. And you can see there was a flat dollar for an adult or a child with a maximum for each family. With the tax bill that was passed in 2017, the individual mandate has been taken away, now not repealed, it has been brought to zero. So it's still in the law, but there is a $0 penalty or a 0%. And then there was an auto enrollment provision, and that has been repealed as well. Then there's the employer coverage mandate, what most employers are going through right now, and to report to the IRS. This was a tax for not offering that MAC or minimum essential coverage to their full-time employees and their dependents up to age 26, and that had to be done within 3 months of hire. There was a $2,000 penalty for any full-time employees if a person went out to the marketplace and got a premium tax credit. And then if the coverage also did not meet affordability or minimum value, there was a $3,000 penalty. As of 2019 and every year since this started, those amounts have been increasing on a cost of living and kind of an inflational rate. So as of 2019, that first, what I call the A penalty, the $2,000, is now $2,500, and the affordability minimum value is up to $3,750. That affordability coverage is at 9.86% of an employee's household income. That has been going up and down every year since we started, and right now that's safe harbor. It equals about a $99.75 premium at federal poverty level rates. And from a value, this has not changed. The minimum value plan must cover at least 60% of the total medical services at what we call a standard population. That's a bronze plan. And then it must also cover prescription, physician services, and inpatient hospital. No lifetime limits are allowed, no annual caps on those essential health benefits. There is an annual premium rate review. We move every year with out-of-pocket limits, and you can see there that these two for 2019 have been increased. From a plan renewal standpoint, we make sure that each plan has this, and then they are run through an analysis to ensure that they meet that minimum value standard. Coverage for pre-existing conditions, we all know that phrase. We've heard it a lot since the Trump administration has come into play, and we've gone through these repeal and replace conversations. Essential health benefits, preventative care, mental health care, all of these must be covered. And then you can see there are some medical loss ratio rebates if expenditures exceed a percentage of premium. So there is something also part of this, which is probably the one piece that hasn't exactly been working across the board, even with the ACA, and that's cost containment. And through these, we had Medicare savings, and we've seen a lot through reduction in Medicare access payments. You can see growth capitation, IPAB payment oversight. A lot of critics were concerned that any Medicare cuts might mean that plans might withdraw from the program, but according to the Kaiser Family Foundation, enrollment actually increased from 24% in 2009 to 31% in 2016. There have been some short-term savings at the federal level, about $68 billion between 2011 and 2016. There have been changes in the Medicare Access Program within CHIP Reauthorization Act, and these kind of move things from fee-for-service to different types of payment models. You can see how there are medical homes, some readmission incentives. We've been talking a lot about ACOs, and of course, wellness programs. A lot of these are still being deemed what we'll call proof of concept, trying to identify, do they work, do they have the power to stay in the long term, and will they have any real effect on costs? A lot is still to be seen, but cost containment is a major conversation topic, especially with the GOP and with the House being now run by the Democratic Party. The likelihood of any type of repeal conversation is pretty much off the board. So they seem to be focused on cost containment, and we'll have more about that later. There's also this illustrious Cadillac tax conversation starter in many a boardroom. This was a tax as part of the ACA that was there to basically say, hey, don't make your plans too expensive, because that leads to overconsumption of healthcare and is contributing to this cost growth that seems a little bit uncontrollable. So what it was, or is, 40% excise tax on employer-sponsored insurance. There were limits to that, so it's about $11,000 a year for self-only, $29,000 for family. That definition of high cost keeps changing. It has been delayed twice. It was originally scheduled to go into effect last year in 2018. Those rates there are expected to be about $11,200 and $30,150 by 2022, when it is slated to go into effect as of the last conversation. But like we said, they seem to be kicking the can down the road. We don't know if it will ever get repealed, but you can see there the last bullet is the big one, an estimate of workers in employer-sponsored plans that would be affected by 2025 just based on the growth cost in premiums. So with that, I'm going to pass the next section over to Brian.
Thank you, Allison. Jenny, how do I advance the slide down again? Okay, we're going to talk about 5 things, 5 categories as they affect the current landscape of the ACA. We're going to talk about where we are with repeal, Medicaid expansion, some state individual mandates and state law attempts to replace the ACA, health insurance expansion, and some executive orders issued by President Trump. So the first topic would be where does repeal stand? So as Allison just mentioned, repeal of the Affordable Care Act is completely off the table. And when Republicans had control of the House and the Senate the past 2 years, and there's a slide on this later, they had 70 plus attempts or 70 plus bills were introduced to repeal the Affordable Care Act. Nothing ever happened. They did do some things we're going to discuss to try to weaken the Affordable Care Act. And one of the big ones, and you've seen a reflection of this in the recent Texas District Court decision, is the individual mandate. And like Allison said, the individual mandate has not been repealed, although a lot of people think it has. It's been reduced to it's either $0 or 0%. And as an aside, the current district court case, which is now on appeal to the Fifth Circuit, which, by the way, has been stayed because of the government shutdown, if the House were to pass a bill, and admittedly there's no chance of this getting through the Senate, but increasing the individual mandate penalty to $1 or even a penny, that would eliminate all the legal issues in the case because the tax would be back in place. That's all it would take, would be $1. So again, full Democratic control of the House. So what I think you're going to see is things that will change the Affordable Care Act at the margins. You will not see a full repeal. There won't be any attempts to do so because the Republicans couldn't get it done when they had full control. All right, Medicaid expansion. Government funding, 90%. What does this mean? So when the Affordable Care Act was passed, it required an expansion of eligibility for Medicaid. And what that meant is that beginning in 2014, states had to provide expanded coverage, and the way the law was written was anybody who was at or below 138% of the federal poverty level, and that's about $15,500 for an individual. So what the law required was that the first 3 years it was in effect, 2014, 15, 16, that the federal government would cover 100% of the costs of that expansion, and then it would gradually reduce to 90% by the year 2020. In fact, last year it was 94, this year it's 92. So the Republican challenges that you've seen to this law is centered on the fraction of the expense that the expansion would shift to the states, which as at most is 10%. This is also an issue that was central in the 2012 case, which was NFIB v. Sebelius, that upheld the constitutionality of the Affordable Care Act as a tax. One of the things that was ruled in that case was that the Medicaid expansion was not constitutional and could not be forced on the states. So what we're down to now is 36 states are participating. The 14 that are not are all red states. There has been some expansion recently in some very deep red states to expand Medicaid. That would be Idaho, Nebraska, and Utah. Also Maine and Montana. Maine recently elected a Democratic governor, and so Maine is going to opt into the Medicare expansion. Montana is as well. So what you're seeing now with the 14 states that have not opted in, they're all southeastern and midwestern red states. Some states have imposed requirements that people work in order to be eligible for Medicare. That is having in those states a somewhat negative effect on participation. So that takes us to the topic of block grants. That's a term that you see in the media frequently, but if you're like me and you spend your time working on your company's health plan and then you have experience with your own benefits, you're not familiar with a block grant. So what is it? Well, right now, Medicaid covers 75 million people in the United States. And what a block grant is instead of funding Medicaid like the federal government does now, it's that the concept is states would get fixed federal grants based on the amount of Medicaid spending in that state, and it would grow each year to account for inflation. A block grant doesn't increase as much as the medical inflation rate. It's based on the general inflation rate. And, you know, the 90% that we talked about in the first bullet point, right now the federal government, and that was for the Medicaid expansion, not for Medicaid in general. Right now, the federal government funds Medicaid at the state level based on where that state stands regarding how much money its citizens earn, the overall wealth of the state. For example, Mississippi gets the highest federal subsidy at about 75%. Massachusetts is the lowest at about 50%. So federal funding is open-ended, but in return, the states have to agree to expand their coverage requirements, which, you know, may not be a bad thing because it would make it more uniform across the states versus what it is now. We could probably spend a next hour talking about block grants, but it would be a big change to the way that Medicare is currently funded and administered. So that might be a legislative proposal you will hear about, and I would imagine you will. All right, the next topic is the individual mandate. So again, the individual mandate has not been repealed, it's just been reduced to 0. The next bullet says that you have 9 states and DC that are considering individual mandate. What's actually happened is Washington, DC has passed it. It's effective this year. Massachusetts has passed an individual mandate. It was effective in 2018. New Jersey's individual mandate is effective this year as well, and Vermont is 2020. This is all in response to the elimination of the penalty at the federal level of the individual mandate. So a lot of states are looking at this. This again, like what we just talked about, could lead to differences in coverage between red states and blue states. You'll notice a lot of the states, that every state that has passed it so far is a blue state. From an employer perspective, an individual mandate doesn't necessarily cause us too many compliance headaches. But what you do have is Massachusetts in 2018, in connection with their individual mandate, they also passed an employer healthcare contribution requirement, which is basically a state-level pay-or-play type law. Vermont's got that coming online next year. And that is a compliance headache for us as an employer. If all the states pick this up, we're going to have to add people just to be able to be compliant with this compliance requirement. Okay, next is health insurance expansion. So cost sharing reduction payments that were stopped by President Trump in the third quarter of 2017. What's a cost sharing reduction payment? Those are payments made by health insurers by the federal government, and it compensates them for offering discounts to their lower income customers. And so what a cost sharing payment did was it provided stability in the market. And politicians that are cast as liberal are seen in support of this as a way of expanding coverage to more people. But after the cost sharing payments stopped, what actually happened? Well, a lot of states and insurance companies adjusted to that move. Premiums went up, and insurers actually got a bigger federal subsidy than they would have otherwise received. So in a roundabout way, this actually turned into a better deal for some people who received subsidies more than not. I think to bring these cost sharing reduction payments back would cause more confusion in the market. I think one thing you'll see legislatively may be an end to this because the market did adjust to the absence of those payments. All right, next is executive orders. So there was an executive order that President Trump issued in October of 2017, and it covered association health plans, short-term limited duration insurance, and one of the how it affected association health plans was the executive order said that large employers are able to provide their employees with very cost-effective health coverage because of their purchasing power and the discounts that they're able to drive. And expanding access to association health plans can help small businesses overcome that disadvantage because it allows them to band together to either self-insure or to purchase large group health insurance. I spoke at another conference recently, and someone from a large law firm commented that, and this somebody who was a partner, that they had a $12,000 a high deductible plan, and they paid $2,000 a month for that coverage. And I told them that I had a $3,000 per year high deductible plan, and I paid $50 pre-tax for that coverage. So I think that's a pretty good illustration of the purchasing power that a large employer can drive. And I'm grateful to my employer for providing that benefit to me and everybody else who works here. So Short-term limited duration insurance. So limited coverage, short-term plans, those are exempt from the marketplace requirements of the Affordable Care Act. And when President Obama was in office, the regulations governing short-term insurance were written to reduce the allowable coverage period from 12 months to 3 months. And it also prevented extensions selected by policyholders beyond 3 months. And so what the executive order and then the resulting regulations did was they extended the length of time that those plans could be purchased for up to 12 months. There are a lot of inherent issues with short-term coverage, but if somebody is looking for less expensive coverage that provides basically catastrophic coverage for a limited period of time, it would be a way to get it. Medicaid block grants we just talked about. So let's move on to the next topic. What happens after the individual mandate? So individual mandate went away. It's now 0. This year, and that should say 2018, not 2019, 8.4 million people signed up for coverage via the exchanges. And I'm sure you all heard in the news about how the registration window was cut by a third, and the communication budget for people who were called navigators to help people select plans in the exchanges was cut by 75 to 90%. So, there's still a real demand for this coverage. You get conflicting reports on whether coverage through the exchange is good coverage or whether it isn't. Anecdotally, I've talked to some younger people who have exchange coverage, and it seems like if they live in a larger city, they can get access to coverage. If someone does not live in a major metropolitan area, they have to travel to find a doctor who does participate in the exchange. So, I think it's likely we're not going to see the same level of focus on healthcare in the next 2 years, or the same kind of focus that we've seen in the past 2. I think what you'll see is hopefully some more compromise. You'll see changes to the Affordable Care Act at the margins, but no more repeal and replace efforts. All right, so what has Congress done to the Affordable Care Act? Like I mentioned before, when the Republicans had control of the House and the Senate, there were over 70 legislative attempts to repeal the Affordable Care Act. None of them worked. You had the American Health Care Act, which was passed by the House, got a lot of fanfare, went absolutely nowhere. That bill would have offered a tax credit mechanism to replace the subsidies. It would have allowed insurers to charge older people up to 5 times as much for coverage, and currently the Affordable Care Act only allows 3 times. It would have cut Medicaid. Insurers would have been allowed to charge a 30% premium to people who had a gap in coverage, thus encouraging people to have continuous coverage. It would have allowed states to opt out of certain provisions of the Affordable Care Act, and still, if people obtain coverage, that would have counted as qualifying coverage. And it would have removed the tax on investment income that was imposed by the Affordable Care Act. But again, that went nowhere. Some of these concepts may get introduced again during this next Congress. I wouldn't see a repeat. I wouldn't expect to see a repeat of the AHCA, but I think you can expect to see some of its elements. All right, the Tax Cuts and Jobs Act, which was passed and signed by President Trump at the end of 2017. Again, the big thing that did, it reduced the individual mandate to 0. Like Allison said, Cadillac tax has been delayed for a 3rd time until 2022, and I'm hoping it gets delayed one more time because that's after my projected retirement date. So the final thing, the Restoring Congress for the People Act, that was passed by Congress just a few days ago. By the House on January the 3rd. And it's going to do It proposes to do some things like require that members of Congress have 72 hours minimum to review bills before they're voted, that they have a consensus calendar so that to help them better track and move legislation through. There's a bipartisan committee that's going to look at modernizing how Congress works. It bans members of Congress from sitting on corporate boards. But the big change is it allows Congress to suspend the debt limit by passing the budget, which you may remember from years back was originally proposed by Senator Gephardt from Missouri. So you'll hear that referred to as the Gephardt rule. And then finally, what the Restoring Congress for the People Act would do, and I think this is redundant, but it would allow the House of Representatives to intervene as a party in the Texas v. Azar case that's up on appeal. All right, so how has the White House tried to attack the Affordable Care Act? Like we talked about a couple of slides ago, the funding for the exchange outreach and support by the navigators has been cut by 90%. The enrollment window was reduced by half. Cost-sharing subsidies were cut off by the Trump administration, but the marketplace adjusted. What is the FF Shop Exchange? I'll admit I had to look that one up. That is the Federally Facilitated Small Business Health Options Program. And that one was a little bit of a surprise because normally everything this administration does is targeted toward helping small business, and this didn't seem to do that. We're going to get into this in detail a little later. Expanded the use of association health plans. Basically, the benefit there is it allows plans to be sold across state lines, and that may have been why the FF Shop Exchange was ended. Short-term limited duration health insurance was made easier to offer, again, extended from 3 months to a year. Expansion of state waivers. So basically, a state waiver allows a state to propose to CMS how they're going to implement changes in the exchange that's offered in their state. And a lot of these have been approved, particularly the ones that are targeted toward elderly and disabled participants. But one of the things that a state innovation waiver can't do is it can't increase the federal deficit. So a number of these are currently pending with CMS right now, but again, I'm not sure if they're being considered due to the government shutdown. I don't think CMS was affected by that. The administration stopped defending the ACA in court, but as everybody knows, approximately 20 state Democratic attorneys general took up the cause and intervened. And then there have been a number of regulations regarding various Affordable Care Act initiatives that were delayed indefinitely by the administration, so the tri-agencies are just sitting on them. Okay. CMS expansion of state waivers. You can read the bullet points. One of the things that this does, if CMS grants the waiver, is it creates a difference in how these plans are operated, offered, and implemented from state to state. And one of the things I think is good is if you can have uniformity as an employer that operates in all 50 states without the protection of ERISA, and if we had to comply with all the different state laws, it would basically be impossible to offer health benefits. So while in a sense the waiver program is good because it allows states to adjust for their own demographics and needs, at a certain point you also have to have uniformity to make these things easier to administer. All right, next. So what's happened since the ACA has gone into effect? I mean, whether you agree with it or not, the reality is the ACA gave a pathway for a lot of Americans who didn't otherwise have coverage to get it. And depending on which set of statistics you believe, 20, 30, 40 million people now have coverage who didn't, a lot of whom had pre-existing conditions. So, the points on the slide, I think we've all heard before, that the U.S. spends more per capita than other high-income countries. Our health outcomes aren't as good. Our social spending's higher, and that we're the only developed country that does not have single-payer health care. So, is this all a move to push us towards single-payer health care? I think it probably is. I think that's the ultimate goal of all this. Keep in mind what you do have, say, in Great Britain and Canada, countries that have single-payer health care, is you also have people who have supplemental policies that will get them to, quote, the front of the line. And so it's basically a trade-off between the rich care that people had prior to 2012 and providing basic care for everyone. So what's happening to premiums in the marketplace? In contrast to the executive order that I referenced earlier, which has a statement in it that premiums in the marketplaces have doubled since 2013, the premiums in the marketplaces actually went down from 2017 to 2018. The Pioneer Medicare program, that was an initiative launched by CMS in 2012, and it was designed, and it's only in place in 6 or 7 different areas of the country, but it's where you have accountable care organizations work together. They're integrated with Medicare. They have alternative program designs, and they all participate in the Medicare Shared Savings Program. And so if they achieve certain outcomes, bonuses are paid, and you can see the statistic. This is the last year I could find anything on it, that the bonuses paid were actually greater than the savings, but what that is held up as is showing that the model works. So the question there is, can it be rolled out to a broader part of the country, or does this only work in limited locations? All right, the next bullet, 79% of hospitals will be penalized for readmissions under HRRP. That's the Hospital Readmissions Reductions Program. That's a Medicare-based purchasing program, and it reduces payments to hospitals with excess readmissions. That's obviously in place all across the country. So, again, it's one of these initiatives that links reimbursement with the quality of healthcare provided, with the view that if you don't have a readmission, then the quality of healthcare you provided during the first visit must have been high enough. So that's what would qualify, or that's what would exempt someone from a lower reimbursement rate. So that's what that is. All right, medical inflation. Allison talked about this a little. Medical inflation is 18% of our GDP. That's a huge number. $3.5 trillion, $10,000 a person. This trend has been going on. I think any of us would say you've been hearing about it in the news for at least the past 15, if not 20 years. And where does it all stop? Where does it all end? I don't know the answer to that, but I do know it just keeps going up, and it's a problem that eventually is going to have to be dealt with and solved. And so at this point, I will turn it over to Susan.
Try again. I think you're unmuted.
Great. Would you mind putting it back to the litigation challenge slide? I think that got skipped ahead somehow.
Absolutely, I will. What we want to do before we jump into the litigation challenge, and then we'll jump back, is we have a polling question for our audience to engage them between the sessions. And so everyone on this call that maybe didn't join us for the previous session, if you would look to your right, there's a little area that's called polls, and it's question, dashboard, attendees. Right underneath that, you'll see polls to your right, and we'd like you to try to participate. So have you or your employer clients begun receiving IRS fines? We just want to know if it's yes, no, or I don't know. And we're going to launch the poll now. Now we have a few seconds for you to answer. Just a couple more seconds here. All right, interesting results. We had 19% of you on this call today who have received fines, 53% who said not yet or no, and 28% say I don't know. So interesting results there. Thank you so much. I'm just going to go back one slide here. And take it away, Susan.
Great, thank you. What we are seeing, and I need to advance it actually one more to the Texas v. Azar slide, please. Thanks, Brian, to that amazing overview of everything that we've got up till now. Where we are now, and actually the slide prior to that, please. There we go. We have litigation going on a number of fronts with regard to the Affordable Care Act. The most important one, and the one that everyone has been focusing on, is Texas v. Azar. This actually was a lawsuit that was filed prior to the Trump administration taking over, and there were red states that were suing, alleging that the Affordable Care Act was unconstitutional. When the Trump administration declined to defend the Affordable Care Act because they didn't support it and were trying to repeal it, blue states, through the form of attorney generals of these various states, have intervened to defend the Affordable Care Act. The basis, there are many theories under the litigation, but the main one is that the individual mandate survived an earlier constitutional challenge because it was deemed to be a tax by the Supreme Court, and that Congress had the authority to enact the tax under the budget reconciliation process. Because that was the basis upon which the law was upheld, when Congress repealed the tax penalty associated with the individual mandate and reduced it to zero under the Tax Cuts and Jobs Act, that became the basis for the argument that the Affordable Care Act was no longer constitutional because it no longer contained an individual tax. There was a U.S. District Judge, Reed O'Connor, in Fort Worth, Texas, who recently, in middle of December, ruled in favor of the plaintiffs and went above and beyond what many thought the outcome would be and declared the entire law unconstitutional. And his reasoning was that because a key pillar of the ACA's three-legged stool that we talked about earlier was unconstitutional, the rest of the law could not be severed from that. It was inextricably intertwined, that there was no severability clause in that particular piece of legislation, and therefore the entire law had to be declared unconstitutional. So if you look at the next slide, you can see on this slide that we have a map of the United States. And if you see the slides that are in red, those are the states that are seeking to find the Affordable Care Act unconstitutional. Those are the states that have joined as the plaintiffs. The green states are the states where the state attorney generals have intervened to defend the law. And then the white states are basically Switzerland that are staying out of it for now. And so we do have sort of a dichotomy between states that want to support and uphold the Affordable Care Act and those that don't. And what's interesting is this also spills over into states that are asking for innovation waivers under the Affordable Care Act, or on the opposite side, states that are implementing their own mini ACA statutes and protections in the event that the Affordable Care Act on a federal level is found to be unconstitutional. There will be sort of a backstop at the state level. There will be state laws that put protections in place there. And so one of the outcomes of this litigation, depending on whether the law is upheld or not, you could see a real difference in the states regarding individual protections vis-a-vis health insurance, as well as what states have to offer in terms of support for their citizens with respect to health insurance. So if you go to the next slide, there's a number of other pieces of litigation. For some reason, my thing is not working. There we go. There's a number of other pieces of litigation that are also affecting the viability of the ACA. I will go through these very quickly because I think we want to get on to talking about tax penalties. and why they are still important even though we have this litigation going on. But there have been challenges to Section 1557, which is the non-discrimination portion of the rule. There have been challenges to the association health plan rules that the Trump administration issued that are already in effect, and many association health plans are already starting to be formed. Certain cities, safe haven cities, have challenged the Affordable Care Act, arguing that it is not executing the law faithfully by undermining it through things like not funding navigators, not having a long enough open enrollment period, doing away with some of the federal funding. There's also been litigation against the EEOC with respect to their wellness plan regulations. We've had other sessions on those rules, but those have been withdrawn in light of that litigation and probably won't be reproposed until sometime this summer. We've also seen litigation on behalf of the states trying to compel those CSR payments. And then the big one, though, really is the Texas v. Azar, where this holding is that the ACA is constitutional. So does that mean that we shouldn't be enforcing the law at all now? The answer is no. If we go to the next slide, we will see that if you go on to the next slide, Jenny, if you wouldn't mind advancing that. Oops, back one more. There we go. So the Democratic state attorney generals that are defending the health law announced that they've formally launched their appeal of the O'Connor ruling. So there's definitely been an appeal of this case. Actually, back one, please. I'm not sure how this thing is going on its own. Anyway, they felt that it's being spearheaded primarily by the California Attorney General, and they are arguing that there was an overreaching under the law and that it was wrongly decided. What's interesting is if the case were to reach the Supreme Court, the 5 justices that originally upheld the ACA as being constitutional based on it being a tax, including Chief Justice Roberts, those individuals are still on the Supreme Court, although there is a different fact pattern in front of them now that the Tax Cuts and Jobs Act has reduced the amount to 0. It's unclear how they would rule, and this could go on for quite some time. I would say it would take well over a year for this to wend its way through the courts. The ruling basically was in favor of the plaintiffs, the red state governors and state attorney generals. And as we said before, because there was no severability clause in the ACA and a portion of it was held to be unconstitutional, now that the individual mandate has been zeroed out, the law itself should be held invalid. So if you go to the next slide, this is a portion of the law that was added after the original Affordable Care Act, and so another in this case is whether these additional bits of it would also be held to be unconstitutional. So there's an open question here with respect to that. We can just skip to the next slide because I would like to get to that, the more meaty. So if the individual mandate, some of the critics of this law, of this holding rather, say that Congress did eliminate the individual mandate tax penalty and reduce it to 0, but they left the rest of the ACA intact. And had they meant to invalidate the entire law, they would have done so. So you shouldn't be looking at the congressional intent back when the law was enacted, but you should be looking at congressional intent around the time of the Tax Cuts and Jobs Act when the elimination of the individual mandate occurred. So there are arguments to be made for that. In addition, there were already arguments that were looked at in the prior case that ruled that the penalty is a tax, although it's not a direct tax, so that it doesn't need to be apportioned among the states, and therefore it really was a valid exercise of congressional power in enacting the ACA, and that therefore the entire ACA should not be struck down. Next slide, please. So if the ACA is repealed with no replacement, there would be pretty catastrophic effects about that. There's been studies done that have shown that about 32 million Americans would be uninsured by 2026. Premiums would jump back up to the levels that they were trending before the ACA was enacted. Many jobs would be lost due to individuals who are working on the exchanges and in all sorts of different industries that support compliance with the ACA. And all of the millions of Americans that have pre-existing conditions would be, once again, at risk of having coverage denied to them or very high premiums at a minimum. In addition, there have been some proposals that have put forth with respect to perhaps we should have universal coverage. This is a very controversial decision that's being put through, and it's unclear whether this will go through or not, but a lot of the more recent individuals who've been elected to Congress have been pushing the idea of Medicare for all. It could either be for a Medicare expansion, either to a certain age limit, to lower the age limit by which you could be eligible for Medicare, or to open it up to all individuals. And then I just realized, Allison, I'm going on some of your slides here. So
oh no, please go. Nope, keep on going. You're doing great.
One area where I think we've seen a lot of activity recently is health reimbursement accounts. The HRAs are an area where the Trump executive order gave an order to the Treasury Department, HHS, and the Department of Labor to propose and relax rules upon which HRAs could be expanded and made more available for all. And so they sort of relaxed the integration rule, which would allow it to be integrated now with individual insurance, and also created new types of accepted benefit HRAs. Those rules are still proposed and they aren't finalized. They've garnered a lot of comments. They probably won't be taking effect until 2020 if they do go into effect. But that's another area where we've seen some alternative ideas to what's going on currently with the ACA health insurance exchanges. And I think what we may want to do, given the time constraints that we have, I don't know if the group would be amenable to that, but we may want to jump ahead to talking about some of the deep dive into the 2018 reporting penalties and triggers, because I do see that we're running up on our time. I think if we switch to that, we've really touched on a lot of these other things, and you'll have the content of the slides to go back to. But here I think is some of the meat that we want to get into. Basically, under the Affordable Care Act, what employers need to know now, onto the next slide, is that, you know, this Texas ruling created a lot of uncertainty as to whether there would continue to be enforcement of the ACA or whether it would be on hold pending its winding its way through the court. The judge basically did not issue an injunction, so the ACA does continue to be in effect. It's currently on appeal, but the appeal has been stayed because of the shutdown. And so really everything is on hold right now, but I can verify here and vouch for the fact that the IRS is continuing to enforce the employer shared responsibility requirements. Just this week, I had a number of clients that actually got notice 220Js, which is the actual notice for demand and payment, rather than the letter 226Js. And we're going to talk about what all these mean in a minute. But it's clear that the IRS has moved straight from its, you know, informational letters and allowing employers the opportunity to sort of rebut the finding that they might owe an ESRP and go straight to enforcement. And once you get this notice of demand and payment, which is the letter 220J, penalties and interest start accruing. And conveniently, no one is at the IRS to answer questions or help you through these issues because of the shutdown. So then the question is, do we go ahead and pay these taxes to stop penalties and interest from accruing and then try and reclaim a refund down the line, or what's our strategy there? So you do have to remain in compliance with the employer shared responsibility requirements until the Texas v. Azar case has been finalized. The IRS is continuing to enforce. And so it's really important that you focus on this today. We did get a poll that 20% of you on the line today have gotten some sort of notification from the IRS that you either might owe a tax or you do definitely owe a tax. But I can vouch from our client base that it's much more prevalent, and not only A penalties, but B penalty letters and notice of demand and payment are starting to come out. So on the next page, you know, the Form 1095Cs are supposed to be provided to employees by March 4th of 2019. That deadline was announced as an extension in November of 2018. It's highly likely, I would think, that the IRS may issue another extension due to the shutdown, although we don't have a lot of experience. There haven't been current shutdowns, and certainly not one for this long. The IRS has tended to give extensions in the past when there have been situations that are, sort of force majeure beyond the control of individuals to comply. But if there is no extension, those are due March 4th, and then the 1094Cs and copies of 1095Cs have to be filed with the IRS. The paper filings are due at the end of February, and the electronic filings have to be completed by April 1 of this year. So we do have good faith transition relief, but these IRS letters, 226J, 227L, 220J, all of those are continuing to pour out of the IRS. So despite there being no humans working there right now, the computers are still up and running and spitting out notice for demand and payment letters for those. I just want to quickly go over the penalties again, or the requirements, and then Allison's going to jump in and talk to us about what she's seeing in the trenches on some of these notice letters. So as you recall, if you have 50 or more FTEs, and that includes full-time equivalent employees on a control group basis, you are an applicable large employer and you're subject to the ACA's employer mandate. A lot of employers were surprised to find that even though they only had 5 or 6 employees, if they were part of a larger control group, they got sucked into reporting. And so a lot of the letters that are coming out are around that scenario there. You're required in 2015 to offer minimum essential coverage to at least 70% of your full-time workforce, which includes dependent children, and that coverage has to be minimum value and affordable in order to avoid both A and B penalties. But for sure, you have to offer the minimum essential coverage to at least 70% of FTEs to avoid the larger A penalty. And then that percentage requirement jumps up to 95% for the 2016 tax year. So there's a much lower threshold by which you can not comply. And failure to meet these requirements will result in the 4980H penalty. So Allison, I would love to hear some of the experiences you're having, really being on the front lines there with respect to these penalties and letters.
Absolutely. I think the biggest one, as Susan did say, these 226J letters are appearing. We saw them. They started about a year ago for the 2015 tax year. This letter, which of course I think has gotten caught in a lot of people's inboxes or somewhere else because they're sent to the addresses that are tied to the individual EIN or company level reporting. So we find them floating around a lot, and that's resulting in a lot of I didn't answer, so then they're getting these 220 letters instead. But what we are seeing is a number of the good faith is in place. The IRS has been, prior to the shutdown, responding quite quickly to just problems with reporting. We've got a lot of oops, I forgot to check that box. Or the general, I just chose not to file is not a good answer. But for those that made an attempt, they're taking the 14764 and 14765 response letters and responding quite quickly that they're abating anything and basically bringing the penalty or the proposed penalty to 0. There was a thought that maybe it wasn't going all that well. And the IRS was having a slowdown. Well, the 226Js for 2016 tax year have already hit the pavement, so we are seeing those. So this is going to be a continuous process. So we just want to notify that when you feel like you're done with reporting for the year and you take a big breath, everyone needs to keep watching the mail to see if they get any of these letters and respond quickly because the due dates come very fast. There are about a 30-day window that they give you to respond. The generosity of the IRS, they do allow you to get an extension, but you've got to make sure and call and get that request in as quickly as possible because they are holding to those dates. And it's the date on the letter. Unfortunately, it's not the date that you actually open that envelope and start the process. So along with that, the 226J is the original letter that you receive identifying that there is a proposed penalty. And then we go into the response, which again is the 14764, 14765, And then letters 227, you can see we go through the alphabet. Feels like you're doing your 1095s all over again. But different letters acknowledging receipt of the letters that you sent back to the IRS along with your forms, and then whether those ESRPs will be assessed or not. So again, you want to look out for each of these. They are different. They all have different meanings. And if you should get that final 220, it is, again, up to you to decide what are you going to do and how quickly are you going to pay or deal with those penalties, or file that appeal and start going basically a little bit like court with the IRS. Again, as I mentioned, the 2016 notices are being delivered. That doesn't mean that 2015 is done. There is a date that everyone has in mind for me where we're filing these and doing ACA management for employers, where April 2019 is a key date for us. It's pretty much the time where they say, hey, they're going to be done auditing with the 2015 tax year and they're going to move on. However, you can see in that bullet that they can assess penalties, again, up to 3 years or as of that filing date. So if we have any companies that realized, oops, I didn't file, and they decide to go back and retro and file, that statute of limitations then applies to those years as of the filing date. Non-filed returns, that's the big one. Again, just deciding, I don't know if this law is going to stick around, so I'm not going to file and I'm going to let the IRS come after me. I will say that the IRS is coming after those organizations, and they can penalize any years where a non-filer, no form was received at all. There are certain letters that are going out to some companies saying that you never filed, but yet you did. There were some issues within the system, especially for small companies and organizations that paper filed, if you can believe it, back in the beginning. Bunch of deliveries got stuck in a warehouse and didn't get scanned appropriately, so it looked like the companies hadn't filed. So the answer is, while it looks like a fake letter, and I don't like using the term fake these days, but if it looks like it's you're being scammed, call the IRS and make sure they are real letters, and they ask that everyone just respond with a simple, I already filed, here's my receipt ID, here's the date that we did file, either through a third party or you did it yourself, and just make sure that you document that and keep that with your records. I will say that since the beginning, the IRS has improved their process. So while we have no humans to speak to right now, their systems have been improved dramatically. Their responses are much quicker. Receipt IDs are coming in when we file the 1094s with the IRS within minutes instead of days. And they do have a targeted focus for the 226Js go forward. They are looking for some of the bigger players, really those organizations that are going to have some large penalty and have some revenue tied to them. Trying to get that to advance. There we go. So minimizing the risk, as I mentioned, we are filing right now here at Health Effects. We have a number of our member organizations that are really not caring about the extension. They want this done and over with. So the print 1095 forms are going out, and so far we've got about 4 million in the hopper ready to go to the printer. But in terms of minimizing the risk of these penalties, data anomalies are the issue. As you know, there's information coming from so many different systems, and we just ask that you pay attention on a month-over-month basis to those things that frequently cause heartburn in the HR arena, changing hire dates, offer of covers, your leave of absence, disability files. Set offers of coverage in there twice, mainly because we've got different benefit carriers and different administration systems, but also anywhere where you might have potential fat finger Social security numbers and bad typing become an issue at the IRS level. We just recommend that with your broker and consultants, you're reviewing and confirming your safe harbors and the rates that you've selected for your individual coverage plans and any strategies that you may have, and making sure that you identify any multi-employer organizations and have that identified within the systems as well. Managing your total number of employees, full-time determination under the law, so under the ACA and the 30 hours, not necessarily what you have written in your SPD. And then watching for what we call fail codes, so your 1Fs when you do have an actual MEC plan that you're offering, or if you do not. Blank safe harbor codes are causing 226Js, as well as 1Hs. When you've got full-time determined people. Again, not having a crystal ball, you might be able to guess how many of your employees have gone out to the marketplace to get coverage or have received a premium tax credit, but it's a guess that for some organizations they may not want to make because it can become a pretty substantial penalty amount. And then last but not least, acquisitions are a pretty huge piece, so we want to make sure we watch those as well. See, we've jumped forward a little, but I'm going to pass this on to Brian.
Okay, in addition to the penalties that Allison just covered, there's also some other penalties out there that you need to be aware of, and I'll pretty quickly go through them. If you violate or you don't have a plan design that's compliant with the Affordable Care Act, the Department of Labor, and they would typically do this on audit in response to a participant complaint, can fine you a $100 a day penalty under the Internal Revenue Code. And, you know, like any good federal penalty statute, there's multiple ways and multiple variations as to how it can be applied. For example, failing to send the SBC summary of benefits and coverage statement, they can fine you $1,128 per day for failure to send that. And just to give you an idea of the scope of what that penalty could be, at one point at UPS, we had, because of the number of different plans that we offered to union employees and non-union employees and the options people could pick, when the SBC requirement first became effective, we had 68 of them. So if we had missed even just one, imagine that per day penalty. COBRA violations. A couple things there. If you're not compliant with COBRA, again, you have the standard $100 a day penalty. And as everybody knows, if you fail to send a COBRA notice late, which sometimes happens if your local human resources people don't timely code when an employee leaves the organization, you can be fined up to $110 a day for that. Typically what cures that is when you extend a person's coverage past the date at which you found out the notice should have been sent, and then you send it and they pay premiums prospectively. You know, we don't ever get hit for penalties because when that happens, we give people coverage and then send them a new notice that's timely. Failing to file a 5500, you can be fined $2,140 per day. This isn't one I don't feel like my company's at risk for, but it's always good to take an inventory of the number of plans you have, because you may have a little plan out there that you're not paying attention to because maybe it's got under 100 participants and you aren't required to file. But maybe you do get up over 100 participants and you are required to file. That's where that one could get you. If you don't provide copies of plan documentations to the DOL on request, they can fine you $152 a day. Again, that would be one that would be enforced on audit. The various notices, like the chipper notice, you can be fined $114 per participant per day for not sending that notice. So it's a good idea just to make that part of your annual plan communication. That's what we do. If your plan design violates GINA, there's a $110 a day penalty under ERISA, and Allison and Susan have already covered the A and the B penalties. So more out there than the employer pay or play. Just be aware of it. Okay, so what happens now? Democratic House, Republican Senate. Susan, what do you think?
Well, I don't think a lot will get done, and certainly if they were able to pass something, it's possible that it could be vetoed. So I do think we'll be in an ACA sort of status quo for the remainder of this year. But I do think that, as you mentioned earlier, Brian, the repeal of the ACA is not going to happen, and it's been in effect for 8 years now. Almost, we're starting into our 9th year. A lot of the immediate market reforms are very popular, certainly with the employer crowd that we have, some of which on this call, and brokers and plans that are on the call. You know, if you try to take away coverage of adult dependent children up to age 26, that could be considered a takeaway, even though legally you might be able to do it. I think that we would have troubles. Certainly the pre-existing condition exclusion was a huge issue in the midterm elections, and it will continue to be important in the presidential election that we have in 2 years, which is already starting to gear up. So I think the Republicans realize that they need to stay engaged in the conversation on healthcare, and merely saying that the ACA is going to be repealed is pretty much a non-starter. If you look back at the slides that you had put together, it's remarkable how much has been done to sort of chip away at the edges, though, particularly not through the statutory process, but through regulation, executive order, and the like. And so, for instance, association health plans, this health reimbursement account expansion, short-term limited duration insurance, giving the states more ability to legislate on their own. All of that is creating a really chaotic atmosphere for trying to comply, especially on a national level. So never a dull moment for sure on that front. What I do think is interesting is that you know, while there are other things that are distracting people right now, and legitimately so, with immigration and the shutdown, et cetera, you can be sure that in many rooms across America, there are people that are coming up with policy ideas. Some of them we mentioned: Medicare expansion, you know, a single payer system that would probably take a while to implement, given all of the stakeholders we have in this country, and it being 18% of the gross domestic product. But it is something that's sort of starting to gain traction. It's not viewed as sort of a strange idea anymore, and even portions of the AMA are on board with this as well. So it's something that will certainly be debated in the 2020 election. Another area that I think that we'll see is employers taking more control of their own destiny with respect to healthcare. So we've been working on a lot of tie-ups between providers and employers, just completely sidestepping the insurance markets. I actually got a letter from my internist yesterday saying that she is going to a concierge model, and if I want to pay a fee, an annual fee, I can get all of these nutrition, weight loss, you know, primary care services for a flat fee, but it won't go towards my deductible, and I'll still need catastrophic insurance on the side. But people are starting to disengage from this dysfunctional system that we find ourselves in and come up with creative workarounds. Another thing that we recently saw, which I think is very important, is this increase on transparency. It's just starting to become more transparent, I should say, but we're starting to see a movement both with regard to the data that employers want to see with respect to their employees, and also hospital pricing that's being required of the federal government with respect to payors in the system, providers in the system. One thing that'll be interesting there, though, is that the types of data that is being required to be disclosed may not be that useful, in that there are a lot of discounting and things that go on behind the scenes. But at least we're starting to get some movement there. And then tying back to our first panel today on the opioid crisis, the GOP has been involved in a number of fronts with respect to the pharmaceutical industry, drug pricing, competition, barriers to competition, et cetera. So we're starting to see a lot of that as well. But I do think that in terms of compliance, and then maybe we can get to some questions, if you go to the next slide, you simply, I think you would be remiss or foolish or imprudent, whatever adjective you want to use, if you were to just say, I don't need to worry about the ACA right now, I can just kind of coast and not do anything for the coming year. The reason being that, as we've been mentioning in the last few minutes, these ACA employer shared responsibility notices and demand for payment are coming out. Once those come out, they have a 30-year time for due date for payment. There's no longer any discussion with the IRS. It's a bill now, and if you don't pay it timely, interest and penalties start accruing. Those would be wiped out if you were successful in your appeal of it, but do you want to, depending on the level of the bill, do you want to pay it and file for a refund? Do you want to go straight to an appeal? We had some employers that were in conversations with the IRS before the shutdown, really making good progress, and now that's sort of been waylaid, and that's going to be delayed as well. So there's a lot of strategic things that need to be done in 2019 to sort of address all that. But certainly the reporting is required. There are also there are penalties under other parts of the tax code that existed prior to the ACA, that if you fail to furnish a tax reporting document to an individual or to file them with the IRS, there's daily penalties that can accrue, separate and apart from the employer shared responsibility payment penalties. So I definitely would encourage everyone to continue on with their reporting efforts. The IRS is definitely enforcing it. On the ruling side, the litigation side, this is going to take some time for this to wend its way through the courts. It will have to be appealed to the Fifth Circuit, which is currently on a stay right now. Once that happens, the parties will have to brief all of their arguments, and there may be procedural rulings and things that need to take place because the House has now intervened as well in that suit. And so that's going to delay things a little bit as well. Depending on the outcome of that case, if it is either, just whatever the outcome is, the other side is going to appeal it to the Supreme Court. So it's definitely going to make its way back up there. And as I mentioned earlier, the original 5 justices who voted to uphold are still on the court. But the facts have changed somewhat since the last time they were looking at the issue. And so it will be very interesting to see how that all works out. We've been very frustrated with the shutdown on a number of fronts. As a law firm, it's affecting all sorts of things, but it certainly is affecting this process. So if you think, one area that I thought was interesting is we are not able to call someone at the IRS if you get a letter 226J. You really have to respond to it in writing, get a return receipt requested by certified mail, make sure you're meeting those deadlines. There is nobody to talk to about making your case verbally. So those numbers, it's possible there could be some relaxation or some good faith relief that's released after the shutdown ends. But for now, I would feel more comfortable for my clients having a record of what's been sent and making sure that's in place. If you're getting letter 220Js without having ever received a 226J, that's something that's definitely appealable. But the problem is once you get the 220J, it is an actual bill. And that's going to start those penalties and interest from accruing. So unless you're very confident in your ability to win that, you probably do want to pay and file for a refund. What else? We're still continuing to see issues with how to fill out the forms. As Allison mentioned, the blanks. I had one client where the question that was asked on the form 1094 C was, do you offer minimum essential coverage to substantially all of your FTEs? They left blanks, and so a blank means no. So that will automatically get you an A penalty for all 12 months if you have blanks on your forms like that. So one good learning tool is if you've gotten 226J letters and you've closed out those issues for 2015, take a look at your other filings that you're doing now and make sure that you're not making the same mistakes. You're not just populating the same data over and over and porting it over. Allison, I don't know if you have some other tips before we get to questions.
No, that's really it. I know there's a tight turn to get the 1095s out to employees, and a lot of people feel that that's a useless form, because it doesn't have to be filed with their taxes. But pay attention to that, and then go back and do a sweep. If you're with an organization, most have a way to review that en masse through spreadsheet versions, and make any necessary corrections before you send it to the IRS, and then continue a review process even after you file, because catching those quickly can limit that liability that you might have at the IRS. And that's the one thing is, again, you don't want to see that A penalty because they're not small.
Exactly. So Jenny, I don't know if we have any questions in the hopper or if you have questions that you wanted to ask.
Well, I think we did have a couple of questions. One going back, one person wanted clarity on something that we presented, which wasn't the tax penalty of $695 in 2018 a minimum and not a maximum?
Yeah, the flat dollar, it was 2.5% or the flat dollar, and then it's kind of on a grader, but there's, the cap to the family amount.
Awesome. I would say, Brian, question for you. What is UPS seeing on the landscape of the arena of fining, and how are you, sort of dealing with these coming in and ensuring that you respond to everyone like you suggested? You had, 68 plans and you couldn't miss one. How are you managing that?
So for IRS audit purposes, we're a large case audit. That means that the IRS agents have office space in our building and they're here every day. And so have we received 226J notices? Yes, we have. And we anticipated that we would. But I will tell you the amount that we have been assessed or will be, because we haven't received our 220 letters yet, but the amounts that we've been assessed for 2015 are very low. They're what we anticipated, and we don't, we think that we owe what we've been assessed. So I don't foresee that we would have to run that through the IRS appeals process or in any way challenge it. I would also say, as an aside, back to the employer shared responsibility payment in Massachusetts, I'm paying the IRS less than what we're paying in Massachusetts.
Excellent. Good job.
You have the reporting that goes along with those states as well. So the New Jersey individual mandate, it doesn't require you to duplicate what you're doing with the IRS, but you have to still file those forms with New Jersey, and their website just went live this week to get everybody geared up for that. So that will not be fun if that starts happening in multiple states.
Right.
We'll have to wait and see what happens on the horizon, and we'll have you guys back out, Allison, Susan, and Brian, to kind of, give us your thoughts on what to do, in the event that happens. And I want to say, on behalf of our organization and the folks that are on the line, great job, and thank you so much for all you do. Allison, we know you take such great care of your clients, and we see health effects everywhere. And we just want to say, thank you for bringing that thought leadership to the table, as well as you, Susan. Your clients are, I just want to say they're very lucky to have you all, because you're diligent, and what you bring to the table brings a lot of information that is needed, and so we all appreciate it, and everybody on the line as well appreciates it. And I will let everybody know that our next presentation will start in approximately 4 minutes. So I want to thank you guys for joining us once again, and we will see you again in the future months to come, and look forward to articles that you produce, and look forward to thought leadership that you all deliver. Thanks so much, you guys.
Thank you.
Thanks, Jenny.